Hello everyone, welcome back to the channel EduTap. I am Arshdeep Kaur, and as you are done with your phase 1 examination, now you need to start preparing for your phase 2. Phase 2 is very important part of your examination which will decide if you go for the interview or not, right? So now the real competition starts. Now you have to be very careful with your preparation. And as you already know that the security laws, they have been given 30% weightage this time, which is huge. You need to start preparing for the security laws very carefully, right? I have been stressing on this point that security laws, they form a very crucial part of your examination. You have to be very careful when you start preparing for this, right? So that is why we will be starting with the security laws itself. And today we will be starting with the Securities and Exchange Board of India Act 1992. Before we begin, I would like to tell you that EduTap has come up with test series for the phase 2. It will include the chapter-wise tests, full-length tests with evaluation and one-on-one mentor support. So this time you also get one-on-one mentor support. And we have also come up with a live crash course for the phase 2, which will include live classes, short notes, test series and one-on-one mentor support, right? So this is going to be very helpful for your preparation. Please make sure that you prepare well this time, right? So any one of you who has not enrolled yet can refer to the link in the description below. Now let's start with the SEBI's Act 1992. Question number 1. Which section of SEBI Act 1992 mentions about incorporation of the board by the name of SEBI? So the answer to this question is section number 3, that is option C, right? Let's read this section. What does this section say? With effect from such date as the central government may by notification appoint, there shall be established for the purpose of this act a board by the name of the Securities and Exchange Board of India, right? So the central government has established this board, that is the SEBI board, right? The board shall be a body corporate. It is a body corporate by the name aforesaid, having perpetual succession. So it has perpetual succession. Perpetual succession means continuance of the organization's existence despite insolvency, despite death, despite retirement, despite any change in the membership, right? So it stays in operation forever, right? So having perpetual succession and a common seal. So SEBI has a common seal with powers subject to the provisions of this act to acquire, hold and dispose of property. So that means the board can acquire, it can hold and it can dispose also any property. Okay? It can acquire, hold and dispose of any property, both movable and immovable. So SEBI has the power to hold, to dispose of and to acquire any property. It may be movable, it may be immovable. It can also enter into a contract and shall by the said name sue or be sued. Since it's a body corporate, it can sue and at the same time it can be sued as well. The head office of the board shall be at Bombay, right? So where are the headquarters of SEBI? They are at Bombay. The board may establish offices at other places in India. They can establish at other places in India, but where is the head office? It is in Bombay. Alright, I hope this section is clear to you. This was a simple section. Moving on, question number 2. Consider the following statements regarding the management of SEBI board. Chairman of SEBI is appointed by the finance minister. This is actually wrong. The chairman, he is appointed by the central government. Chairman should have special knowledge or experience in any discipline which state government find useful to the board. No, it's not the state government, but it is the central government. The central government finds useful to the board. SEBI board comprises of total 7 members including the chairman. This is also incorrect. It actually has 9 members including the chairman. Section 1 of SEBI Act deals with the incorporation of the board. We have just read it is not section 1 but it is section 3. So that means all of these statements, they are incorrect. That is why the answer is D. That is all of these statements, they are incorrect. Let's read the correct statements as against the incorrect ones, right? So it is given in section number 4, the board shall consist of the following members. Now let's count how many members are there. First of all, it has a chairman, that is 1. 2 members from among the officials of the Ministry of the Central Government dealing with the finance and administration of the Companies Act 1956. So 2 members here, 1 chairman, 3 members, 1 member from among the officials of the Reserve Bank, that is 4 members, and 5 other members of whom at least 3 shall be whole-time members to be appointed by the central government, right? So 5 plus 4, that is 9. That is why I have told you that there are 9 members including the chairman, right? Subsection 2. The Journal Superintendent's direction and management of the affairs of the board shall vest in the board of members, which may exercise all powers and do all acts and things which may be exercised or done by the board. Save as otherwise determined by regulations, the chairman shall also have the powers of general superintendents. So, who has this power of general superintendents? It is with the chairman, and directions of the affairs of the board, and may also exercise all powers to do all acts and things which may be exercised or done by the board. The chairman and the members referred to in clause A and clause D shall be appointed by the central government, that is the chairman and D, the 5 members, right? They will be appointed by the central government, and the members referred to in clause B and C, that is the officials of the ministry and the Reserve Bank official, shall be nominated by the central government and the Reserve Bank respectively. The chairman and the other members referred to in clause A and D shall be persons of ability, integrity and standing who have shown capacity in dealing with the problems relating to the securities market, or have special knowledge or experience of law, finance, economics, accountancy, administration, or in any other discipline which in the opinion of the central government shall be useful to the board. So, it is in the opinion of the central government and not the state government, right? So, I hope this section is also clear to you. Moving on, question number 3. As per the SEBI Act 1992, the central government shall remove a SEBI board member from the office under which of the following scenarios: member adjudicated as insolvent, member is unsound mind and is declared by the court, member is convicted of an offence which in the opinion of the central government is morally wrong, or all of the above. The answer is D, that is all of the above, right? So, removal of the members from office, it is given in section 6. The central government shall remove a member from office if he is or at the time has been adjudicated as insolvent. Adjudicated as an insolvent means he has been declared so by the court, right? Second, is of unsound mind and stands so declared by the competent court. So, it is not enough. So, it is not enough that he is of unsound mind, but it must also have been declared by a competent court, right? So, that is why the word and is used here. Is of unsound mind and stands so declared by the competent court. Has been convicted of an offence which in the opinion of the central government involves a moral turpitude. What is moral turpitude? An act that violates the standards of a community, right? So, has been convicted of an offence which in the opinion of the central government, which the central government thinks involves moral turpitude. If he has done any such act, then also he can be removed from his office. Has in the opinion of the central government so abused his position as to render his continuation in the office detrimental to the public interest. So, if he has done any such thing, then he will be removed from his office. Provided that no member shall be removed under this clause unless he has been given a reasonable opportunity of being heard in the matter. So, he has to be given a reasonable opportunity of being heard, he has to be given an opportunity, then only he can be removed from his office, right? And who removes him from the office? It is the central government. Please remember, it is the central government, alright. Moving on, question number 4. As per section 7 of the SEBI Act 1992, in the absence of the chairman, who shall preside over the board meetings? This question has been asked in the previous examinations, so be careful. So, the answer is D, that is the members decide among themselves and choose someone among them to preside over the meetings, right? Let's read the section. The board shall meet at such time and place and shall observe such rules of procedure in regard to the transaction of the business and its meetings, including the quorum at such meetings as may be provided by the regulation. So, all these things they will be provided in the regulations. The chairman, or if for any reason he is unable to attend the meeting of the board, any other member chosen by the members present from among themselves at the meeting shall preside the meeting. So, in normal course, it will be the chairman who will be presiding over the meetings. But in case he is absent, in that case, who will preside over the meetings? It will be chosen by the members present from among themselves. So, they will decide among themselves and they will choose one member who will preside over the meetings of the board. All questions which come up before any meeting of the board shall be decided by majority votes. So how a decision is made in the board, in a meeting of the board, it will be through majority votes. This question was asked, okay? So it is subsection 3. All questions which come up before any meeting of the board shall be decided by majority votes of the members present and voting, and in event of an equality of the votes, the chairman or his absence, the person presiding shall have a second or casting vote. In case there arises equality in the votes, in case of tie, the presiding officer, either the chairman or any other person who is presiding over that meeting, he will have the casting vote, he will have the deciding vote, right? So this was the question which has been asked in the previous examination, right? So all the questions which come up before any meeting of the board shall be decided by a majority vote of the members present and voting, and in the event of equality of the votes, the chairman, if the chairman is present, or in his absence, the person presiding shall have a second or casting vote. Question number 5. As per section 15A of SEBI Act 1992, which prescribes the penalty for failure to furnish information or return, which of the following is the correct about the penalty? In that case, what is going to be the penalty? The answer is it shall not be less than 1 lakh rupees, right? Let's read this section also. This is section 15A. If any person who is required under this act or any rules or regulations made thereunder. So any person who is required under this act on any rules or regulations, if he, number 1, to furnish any document, return or report to the board, fails to furnish the same. He was required to furnish such report or such document, right? And he fails to do the same. Or who furnishes or files false, incorrect or incomplete information, or he does that, or he furnishes such document but that document it is false or it is incomplete or it is incorrect, right? Or who furnishes or files false, incorrect or incomplete information, return, report, books or other documents, he shall be liable to a penalty which shall not be less than 1 lakh rupees but which may extend to 1 lakh rupees for each day during which such failure continues, subject to a maximum of 1 crore rupees. So what is this section saying? That if anyone who was required to furnish a document or a report and he does not do that, or in case he does furnish that but he furnishes some false document or he furnishes some incomplete document, in that case he shall be liable to a penalty. It shall not be less than 1 lakh rupees, and in case it is a continuance offence, right? And in case he is continuing with such act, then it will be 1 lakh for each day, right? It is a continuance penalty. It will be 1 lakh for each day that he makes that default, right? And subject to a maximum of 1 crore rupees, but it cannot in any case go beyond 1 crore rupees. So the maximum penalty in this case is 1 crore rupees and the minimum is 1 lakh rupees. It can go 1 lakh rupees per day up to 1 crore rupees, right? B. To file any return or furnish any information, books or other documents within the time specified thereof in the regulation. So he had a specified time in which he was supposed to do that, but he fails to file return or furnish the same within the time specified thereof in the regulation, or who furnishes or files false, incorrect and incomplete information, return, report, books or other documents, or he files such documents or returns in the specified time but he is giving false information or incomplete information. In that case also he shall be liable to a penalty which shall not be less than 1 lakh rupees but which may extend to 1 lakh rupees for each day during which such failure continues. So minimum 1 lakh rupees, it can go 1 lakh rupees per day that he is making that default, and up to a maximum of 1 crore rupees. And the C part says to maintain books of accounts or records, fails to maintain the same. In case he was supposed to maintain books of accounts or records and he fails to do the same, then in that case he shall be liable to a penalty which shall not be less than, it is same 1 lakh rupees but which may extend to 1 lakh rupees for each day during which such failure continues, subject to a maximum of 1 crore rupees. So the penalty remains the same, but here they have mentioned 3 different circumstances, 3 different scenarios. The penalty, it remains the same. It is minimum of 1 lakh rupees, maximum of 1 crore rupees and 1 lakh for each day for which such failure continues. I hope this is also clear to you. Moving on, question number 6. As per the section 15F of SEBI's Act 1992, which deals with the penalty for the defaults in case of the stockbrokers, which of the following is correct about the penalty if it charges an amount of brokerage which is in excess of the brokerage specified in the regulation? So the answer to this is option D. It shall not be less than 1 lakh rupees, but which may extend to 5 times the amount of brokerage charged in excess, whichever is higher, right? So we also will be reading section 15F. This section is very important and they do ask questions from this section also. So in this section there are 3 different scenarios which have been mentioned, 3 different penalties have been mentioned for each such scenario. So let's go through each of these. These are relating to the stockbrokers, right? So the first one reads as fails to issue contract notes. If he fails to issue a contract note in the form or manner specified by the stock exchange or which such broker is a member. So where the stockbroker fails to issue a contract note in the manner specified, right, in the manner specified by the stock exchange, in that case he shall be liable to a penalty which shall not be less than 1 lakh rupees. So the minimum penalty here is 1 lakh rupees, but which may extend to 1 crore rupees, and the maximum is how much? It is 1 crore rupees, for which the contract note was required to be issued by the broker. The second one reads as fails to deliver any security or fails to make payment of the amount due to the investor in the manner within the period specified in the regulation. Either he fails to deliver the security or he fails to make the payment to the investor, right? In that case, he shall be liable to a penalty which shall not be less than 1 lakh rupees. The minimum remains the same, it is 1 lakh rupees, but which may extend to 1 lakh rupees for each day during which such failure continues. So for each day for which that failure continues, it will be 1 lakh again, subject to a maximum of 1 crore rupees, but in no case it will be more than 1 crore rupees. The third one, and this was the question that was mentioned in question number 6, charges an amount of brokerage which is in excess of the brokerage specified in the regulation. If he is charging excess fee, right, he shall be liable to a penalty which shall not be less than 1 lakh rupees. The minimum remains the same, but which may extend to 5 times the amount of brokerage. It can extend to 5 times the amount of brokerage, right? So 5 times the amount of brokerage in excess. In excess means, so whatever he has charged in excess, that will be multiplied by 5, right? Out of that, whichever is going to be higher, that is going to be his penalty, right? So it will be multiplied by 5, the amount that he charged in excess, that is going to be multiplied by 5. Let's read subsection C again. Charges an amount of brokerage which is in excess of the brokerage specified in the regulation. He shall be liable to a penalty which shall not be less than 1 lakh rupees, but which may extend to 5 times the amount of brokerage charged in excess of the specified brokerage, whichever is higher. Alright, question number 7. Which of the following sections of the SEBI Act 1992 deals with the penalties of insider trading? So this question is also very important. They do ask about the penalty of the insider trading. So please pay attention to this also. It is option C, that is section 15G. So first of all, what is insider trading? Means the illegal practice of trading in stock exchange to one's advantage through having access to confidential information or non-public material information. And what is non-public material information? It means having access to any such information that could substantially impact the investor's decision to buy or sell his security has not been available to the public. Alright, so now let's go to this section 15G. If any insider who, so if any insider who either on his own behalf or on behalf of the other person, either for himself or for any other person, deals in securities of a body corporate listed on any stock exchange on the basis of any unpublished price sensitive information. So if he uses any unpublished price sensitive information for his own benefit or for any other person's benefit, in that case he is liable for what? He is liable for insider trading. Second, communicates any unpublished price sensitive information, or second is that he is communicating that information to any person with or without his request. It can be on request of someone or it can be without his request to such information except as required in the ordinary course of business, but which is not in the due course of business, right? If it is not in the due course of business, he communicates any such unpublished price sensitive information or under any law. And the third one is counsels or procures for any other person to deal in securities, or either he procures any other person to deal in the securities of any board corporate on the basis of unpublished price sensitive information, then in that case he is liable for insider trading. And what is the penalty? Shall be liable to a penalty which shall not be less than 10 lakh rupees. So the minimum penalty here is how much? It is 10 lakh rupees, but which may extend to 25 crore rupees, and the maximum amount in penalty and the maximum amount is 25 lakh rupees in case of insider trading, or 3 times the amount of profits made out of insider trading, whichever is higher. Or it could go up to how much? 3 times the profit. 3 times the profit that he has made because of that insider trading, and whichever is going to be the higher price, right? So let's read the penalty again. Shall be liable to a penalty which shall not be less than 10 lakh rupees. So it could not be less than 10 lakh rupees, but which may extend to 25 crore rupees, or 3 times the amount of the profits made out of the insider trading, whichever is higher. Question number 8. Which section of SEBI Act 1992 defines the penalties in generic for any areas for which specific penalties are not defined? In case a specific penalty has not been given, in that case what is going to be the penalty? So it is given in section 15HB, right? That is option D. Let's read that what is going to be the penalty in that case also. So whoever fails to comply with any provisions of this act, the rules or the regulations made or directions issued by the board thereunder, for which no separate penalty has been provided, shall be liable to a penalty which shall not be less than 1 lakh rupees. So it cannot be less than again 1 lakh rupees, but which may extend to 1 crore rupees, and the maximum could be 1 crore rupees. Question number 9. As per section 5 of the SEBI Act 1992, the central government shall have the right to terminate the services of the chairman or a member appointed at any time before the expiry of the period prescribed by giving him notice of what period. So the answer is B, not less than 3 months in writing, or 3 months salary and allowances in lieu thereof. Let's read section 5. The term of office and other conditions of the service of the chairman and the members referred to in clause D of subsection 1 of section 4. The D clause were the 5 members that we read, right? So the 5 members and the chairman shall be such as may be prescribed. Notwithstanding anything contained in subsection 1, the central government shall have the right to terminate the service of the chairman or member appointed under the clause D of subsection 1 of section 4 at any time before the expiry of the period prescribed under subsection 1. So who has this power? This power vests with the central government. So the central government can terminate the service either of the 5 members or of the chairman, right? For the expiry of the period prescribed under subsection 1 by giving him notice of not less than 3 months, but he has to be given a notice and it cannot be less than 3 months notice, and it has to be in writing, or 3 months salary and allowance in lieu thereof. Or in alternative, what the central government can do is the central government can give 3 months salary and the allowances to that person, and in that case they do not need to give the notice. That is why the term used is in lieu thereof, right? So by giving him a notice of not less than 3 months in writing or 3 months salary and allowances in lieu thereof, and the chairman or the member, as the case may be, shall also have the right to relinquish. Relinquish, as I have already told you, means give up. So they can also give up their service, they can give up their office at any time before the expiry of the period prescribed under subsection 1 by giving to the central government notice of not less than 3 months in writing. So they can also give up their office by giving a notice of not less than 3 months, and it also has to be in writing to the central government. Alright, question number 10. Officers and employees of the SEBI other than the management of the board shall be appointed by which of the following authority? So the answer is SEBI, that is the board itself, right? The board may appoint such other officers and employees as it considers necessary for the efficient discharge of its functions under this act. So who has this power? It is with the SEBI itself. The term and other conditions of the service of the officers and the employees of the board appointed under subsection 1 shall be such as may be determined by the regulations. Question number 11. What factor is not to be taken into account while adjudicating quantum of penalty as per as per the section 15J of the SEBI Act 1992. This is also very important question and it has been taken from a previous year paper, right? So the answer to this is D, that is intention of the violator. Let's read this section also. Which factors have to be taken in account while adjudicating the quantum? Quantum means they are deciding the sentence. It comes after the accused has been proven guilty, right? So they are talking about the quantum. The first one is the amount of disproportionate gain or unfair advantage wherever quantifiable made as a result of the default. Number 2, the amount of loss caused to an investor or group of investors as a result of the default. And the third one, the repetitive nature of the default. So all these factors, they have to be taken into account, but which factor is not mentioned? It is the intention of the violator. While adjudicating the quantum of his penalty, the intention of the violator, it does not have to be considered. Alright, question number 12. All sums realized by way of penalties shall be credited to which of the following funds as per the section 15JA of the SEBI Act 1992? The answer is Consolidated Fund of India, that is option B, right? So all the sums which are realized by the way of penalties under this act shall be credited where? It will be credited to the Consolidated Fund of India. Question number 13. Who has the power to issue directions to SEBI as per section 16 of the SEBI Act 1992? Who has the power to give directions to SEBI? The answer is B, that is the central government, right? So without prejudice to the foregoing provisions of this Act or Depositories Act 1996, the board shall, in exercise of its power or the performance of its functions under this act, be bound by such directions on question of policy. So the central government can give directions related to the question of policy, and this board, the SEBI board, is going to be bound by such direction, right? Be bound by such direction on question of policy, as the central government may give in writing to it from time to time, but the central government is going to give such direction in writing. It is going to be in writing, right? Provided that the board shall, as far as practicable, be given an opportunity to express its view before any direction is given under this subsection. So the central government is going to hear the opinion of the board also, alright? The decision of the central government whether a question is one of policy or not shall be final. So whose decision is going to be final? Whether this question is of policy or not, it is going to be the central government. Alright, question number 14. Every bench of SAT, that is Securities Appellate Tribunal, under section 15L of the SEBI Act 1992 shall include at least. So the answer to this is D. It will have at least one judicial member and one technical member. Every bench, it will have at least one judicial member and at least one technical member. The Securities Appellate Tribunal shall consist of a presiding officer and such number of judicial members and technical members as the central government may determine, right? So the number will be determined by the central government by notification to exercise the powers and discharge the functions conferred on the Securities Appellate Tribunal under this Act or any other law for the time being in force. Subject to the provisions of this Act, the jurisdiction of the SAT may be exercised by benches thereof, right? So the jurisdiction, it may be exercised by benches, and who will be there in the benches? Let's read it. A bench may be constituted by a presiding officer of the Securities Appellate Tribunal with two or more judicial or technical member as he may deem fit. Bench may be constituted by the presiding officer, right? Constituted by who? It is going to be constituted by presiding officer of the Securities Appellate Tribunal with two or more judicial or technical members as he may deem fit, provided that every bench constituted shall include at least one judicial member and one technical member. It shall have at least one judicial and at least one technical member in all cases, right? The benches of the Securities Appellate Tribunal shall ordinarily sit at Mumbai and may also sit at such other places as the central government may, in consultation with the presiding officer, notify. Notwithstanding anything contained in subsection 2, the presiding officer may transfer a judicial member or a technical member of the Securities Appellate Tribunal from one bench to another bench. So they can be transferred, and who can make such transfer? It is the presiding officer. Last question, question number 15. What is the qualification required under Section 15M of the SEBI Act 1992 to be appointed as the presiding officer of the Securities Appellate Tribunal? This is a question that is being repeated number of times, right? So you have to pay attention to this one also. So the answer to this question is C, that is he is or has been a judge of the Supreme Court or a Chief Justice of the High Court or a Judge of High Court for at least 7 years. We are talking about the qualifications of the presiding officer to be appointed at SAT, right? Okay, let's read the qualifications. So, a person shall not be qualified for the appointment of the presiding officer or judicial officer or the technical member of the Securities Appellate Tribunal unless he. So, we will be reading the qualification for all of these, right? First one is for the presiding officer is or has been a judge of the Supreme Court or a Chief Justice of the High Court or Judge of the High Court for at least 7 years in case of the presiding officer. So, what is the qualification? Is or has been a Judge of the Supreme Court or Chief Justice of the High Court or a Judge of the High Court for not less than 7 years in case of presiding officer. Is or has been a judge of High Court for at least 5 years in case of judicial member. In case of judicial member, he has to be a judge of High Court for at least 5 years. And in case of technical member, what is the qualification? Is or has been a secretary or an additional secretary in the ministry or department of the central government or any equivalent post in the central government or a state government. Or there are 2 qualifications and one of this has to be fulfilled, right? Either one can be it. Is a person of proven ability, integrity and standing, having special knowledge and profession experience of not less than 15 years. So, the minimum experience he should have, it is of 15 years in financial sector including securities market or pension funds or commodity derivatives or insurance. Right, I hope now you are clear with the qualifications of all the 3 members, that is the presiding officer, the judicial member and the technical member. This is a very important question, please go through it, right. Now, question for achievers, that is the bonus question. In settlement of administrative and civil proceedings under section 15JB of the SEBI Act 1992, which of the following factor is not considered by the board before agreeing to the proposal of settlement? Nature of default, gravity of default, impacts of default or quantum of default. So, you have to comment the right answer below. So, that was all for today. I hope it was a helpful session for you. For more such videos, please like, share and subscribe to the channel EduTap. Thank you.